Good afternoon, everyone, and welcome. I am really excited today to be having a conversation about the EU AI Act and generally about the regulation of artificial intelligence. I have with me two amazing guests who are both uh, deep experts in AI. With me is Brenda Leong from Luminous Law. She's a partner there. She has been working on AI issues for forever, really, for a very, very long time. And she is my leading go-to expert for anything with AI for years. We also have Calli Schroeder, who is at Epic, and she's leading Epic's AI and human rights project, doing really fantastic work about analyzing AI laws and policy and advocating for protection of people and consumers and rights. And so welcome to both of you. I'm really excited to have you both here. I want to just do a very brief introduction to our topic. I've been kind of delving deep into AI. I actually just created the AI whiteboard. It's these like one-page summaries of the law. So I really kind of delved into the law to kind of learn this and summarize it up. By the way, you can download this for free if you at the registration link for this webinar, or from my site. Just check my social media feed, and you'll hear me touting this and talking about it. I made a course about this for my training company, Teach Privacy, a course in the EU AI Act, as well as another course on AI generally. So I've written a couple papers on AI, looking at the privacy dimension. So I've been really kind of delving deep into the law, trying to understand how this works, but also wanted to think about, is this the right approach? Is this the appropriate approach to regulating AI? I I I want to just take a moment just to summarize the general philosophy or approach of the AI Act. The EU wanted to be, really first out of the gate to regulate here. Actually, technically, Colorado beat the EU to kind of get an act actually fully out there. But the EU AI Act was in the process of being developed and for a while, and is now out, and it's takes a risk-based approach. So unlike a lot of privacy laws, which take a rights-based approach, which really try to essentially give consumers the ability to try to control their data, I think, which is an approach actually I've critiqued in the past. I think that doesn't really work because I think it's too complicated for consumers to fully control the uses of their data. The EU AI Act takes a risk-based approach. It looks at all sorts of risks in AI and tries to classify those risks as either unacceptable risk, high risk, or okay, essentially, or kind of minimal or moderate risk or whatever. But it basically focuses a lot on what do we do with unacceptable risks, which is a general restriction, or high risk, which has a bunch of different requirements. A lot of these are internal requirements that the creators or users of the AI must do, compliance types of functions. And that's essentially how the act works. There is a transparency requirement that people need to know if they're interacting with AI, and a few other things. But that's the gist of the law. But I'd like to get your perspectives, Brenda and Calli, on what are some of the dimensions or highlights of the EU AI Act that you find particularly notable at the broadest level. I'll start with you, Brenda.
Thanks, Dan. Thanks for the chance to be here and talk about this today. That was I think teed it up really, really well. And I think taking that risk-based approach is both one of the sort of strengths, but potential longer-term challenges of the law. there's been already some critiquing of it in the sense that it really only addresses in any kind of detail high risk systems. And so is that really the best approach to sort of just carve out things that are high risk and really only focus on those? And if so, maybe so, then we need to be really, really clear about what is high risk, how we're defining it, how we're identifying it in order to put it in that sort of pipeline of additional requirements. And again, a lot of critique so far that's not quite ready for prime time yet in the amount of detail and guidance. There's a lot of things in the law. We are expecting more guidance both from the EU AI office and individual nations, I think, but some work to be done there. I think personally, I would identify that what I personally like is one of the greatest strengths about it, or one of the most admirable things about it, is this category of unacceptable risk and prohibited use systems, because that is really less about technology risk or technological function and performance risk, and really all about social and cultural decisions about what we want in our society, what we want in a democratic society, what kinds of things we're willing to take. So it's not a question of can the technology be made to function to do these tasks. It's the idea that these are tasks we think shouldn't be done. And so if nothing else, I really appreciate the fact that the EU sort of carved out that top level and said, regardless of what kind of paperwork you could put around it or testing schemes you could build, there's this one category of things that we're willing to say we just shouldn't be doing. So whether that's the right list, whether there should be more things, whether other people make different lists is all certainly up for debate. But the fact that that category exists and that is now sort of acknowledged as one of the decisions we can make to just not do certain things, I think has really a lot of value and could influence longer term approaches to some of these AI informed functions and systems that are going to be more and more present in our lives. And hopefully we can continue to sort of keep that in mind as one of the ways that we distinguish how we choose to prioritize these things in a free and democratic society.
That's great, and I'd like to get your thoughts, Calli, on overview of the act and generally kind of what's in it, what's notable about it.
Yeah, so I completely agree with Brenda's assessment there. I also want to add that there's some components here that are things that at Epic we just really like to see in laws. So I love that they have a section that just wholesale bans certain practices. Many of the practices that are listed in there are things that we would want included that we really want to highlight. Sorry, one sec. Caught up to me there. So there's total prohibitions on social scoring systems, emotional recognition tools in school and work contexts, some predictive policing tools, a few other areas. Those are definitely areas we are happy to see full prohibitions. I love that there are some really good transparency requirements in there. They make some effort to have kind of a clear layout of where liability falls at different points in the AI use system. There's risk assessments on another kind of personal level. I really love that there's a private right of action for people affected by these things. So there are really good things in this act. And I know that the process to develop it was long and involved a lot of debate and input from companies and civil society and government bodies. It seems like there was genuine effort to listen to all of those efforts. Some of the weaknesses, I know we'll get into some of the weaknesses of the text, which I have thoughts on, but one major takeaway I have is that I feel like they may have set themselves up with an unwinnable challenge in building something that they're calling the AI Act. At the time they were initially drafting it, generative AI wasn't really part of the conversation. And to the extent that generative AI is covered in here, it was kind of put in at the last minute. And I would argue that the act itself really doesn't address the particular challenges to generative AI. There's also some real issues with trying to address general purpose AI. In some of the earlier debates, that was intentionally not going to be covered by the act. It was kind of added at the last minute, but the requirements around there are weak. And in many cases, the evaluation of what risk category an AI system falls into is largely based on intent, intended purpose, intended use, that sort of thing. That doesn't really apply when you're looking at a general purpose AI system. So that's a weakness I'm a little worried about. And in general, I think this is such a quickly evolving and complex technology. It's basically impossible to have one act that's going to address every risky aspect of AI. I think this may be a good first step. We'll have to see how it plays out, but I'd be very, very surprised if there aren't multiple steps coming after.
Yeah, that's great, and you both raised really interesting points that I want to dive more deeply into. I think one of the things that I like about the act is that it does take a risk-based approach. I really have long thought that one shortcoming of privacy laws is that they put way too much onus on the consumer to try to figure it all out. I agree that the consumer is kind of very much vulnerable and is in a very helpless position when all their data is being used behind the scenes to do all this about them. But the privacy law says, well, we'll just try to empower the consumer by giving the consumer all these rights. That generally doesn't work very well because it's too much of a burden on consumers, and it's too complex in a lot of cases for consumers to exercise these rights. And I think with AI, I think the EU policymakers realize that, hey, this is really complicated. We can't just throw it onto the consumer's lap to try to figure out AI. So we will take a risk-based approach. We'll define, these risks, the red lines in the sand for the unacceptable risks. But there's some challenges with this. Is that do they have it right? Are the risk categories somewhat arbitrary? Do they leave things out? What do they include in? And then are the steps that the measures that companies must do in high risk sufficient? And also I think there's the issue of what happens, how much is kind of given to the company to decide for themselves what's risky and what's not. Is it giving too much deference to companies to sort this out on themselves versus? And I think this raises a kind of a long-standing, deep philosophical debate in the law, an issue that's kind of pervaded law for a long time, which is how proactive should a law be? How much should a law, when it comes to risk, put the onus on policymakers, make policymakers make the kind of first pass on this, or how much should it be reactionary, wait for something bad to happen and then jump in after the fact, beforehand or afterwards. And when we look at drug regulation, that's regulated very much in a kind of precautionary way. You have the FDA will analyze and approve drugs before they get into the market, and will decide, is this drug going to be okay for over the counter, or do you need a prescription? There's a lot of regulation right at the get-go before a drug ever hits the individual. Do we want that kind of approach to AI, or do we want a kind of a more of, hey, put it out there, let people do stuff with it, and then we shouldn't have the government scrutinizing AI and having to wait for them to say yay or nay for it. And I'm curious what you think about that generally. Is it better to have kind of more government involved earlier on in the process or later in the process? Do we wait for harms, or do we try to act before harms? And I guess I'll go back to you, Brenda, if you have a thought on that.
Sure. There was a lot in that to sort of unpack and think about. As to try to frame it in the way you wrapped up there with the proactive versus reactive, and maybe tie back into some of the points you made earlier as well. I actually think that having the companies involved is a good way to be proactive about it. And I know I'm going to probably risk a lot of pushback, whether from Calli or from other people generally, about capture and driving the train from the market and things like that. But I don't really mean it that way so much as that these are the real world applications and uses that are happening, and nobody is better positioned to sort of identify and inform on how things are happening and how systems are operating, and have the real insight into what kinds of things are both being developed and projected to be done, and are actually operating in the world now. So it's really going to be critical to involve the companies in that way. And one of the things I actually like about the EUI Act, again, potentially controversially, is that they've sort of asked for this volunteer pact ahead of time of companies in the market using these systems to sort of try to start to come together and coalesce around some best standards, or some best practices, or some controlling standards, or some commonalities, at least consensus on what does constitute risk, or what kinds of functionality might align with higher risk systems in line with what's already in the EUI Act, but maybe taking it to the next level of detail or specificity. So, for example, the high risk categories have the Annex 1, which is more sort of physical world machinery, medical devices, toys, things like that. And then the Annex 3 list, which is more sort of the online digital context, but also sort of leaves open this list of factors that if you're not clearly identified in one of those cases, here's sort of the way you self-assess. And those are still pretty broad. Like, it's a list of factors, but one of them is sort of like what harms have already been caused. And it doesn't really say how to measure that, or what the threshold would be for that, or what the cutoff is for that. So if we actually can have some real world use cases and examples and inputs from the operators of these companies, developers and providers of these systems, to sort of inform what would that look like, how could that usefully be applied, and then pull in the government regulators into that conversation to review and solicit more detail, and mold that into whatever level of protection they think is appropriate. I think that's really the necessary balance, or the necessary process in terms of most effective way to sort of to make that happen as a real partnership between the stakeholders, to use the buzzwords for all of those keeping track on their bingo cards at home. And so I like that aspect of it, that it sort of has that incorporation of the company's inputs, because there's a 2-year implementation period, and to make that valuable, to make that time spent effectively, to have companies start working together, start pulling this together, because at the end of the day, the regulator still has the opportunity to look at that and sort of decide what those thresholds will be. They don't have to agree with exactly what ends up landing in the best practices, but it would be an informed input of like, here's why those thresholds might be justified, or what the ranges might be, and why in some cases you might choose to do higher or lower cutoffs, and things like that for both data protection, or for safety, or for the other kinds of concerns that we have, bias, and things that we have when we're talking about AI. So lots more thoughts about all that, but I'll pause there, because I know Calli has interesting things to say about that as well.
So go ahead, Calli. What do you think?
Yeah, I do agree with Brenda that I like that there's stakeholder input here. So before I worked at Epic, I used to do client compliance, and I would be the person that was talking to companies and talking them through, these are what your legal requirements are. This is how we'll do an assessment. This is how we track your data. This is how we'll engage with lawmakers and authorities. And I couldn't agree more that it's completely fair to have the companies involved in that discussion, because they are the ones that know how these things will apply practically. So if they're being open and willing to engage in a dialogue with people that will ask them pointed questions about how they're classifying themselves and what their processes are like, I think that is really helpful. The key is making sure that there's also people in the room where their specialization is identifying what those risks are and trying to address those risks, so that you don't get a spun version of things, which I'm not accusing all companies of doing, but people operate in their own self-interest. It makes sense. One thing that I wanted to raise about the AI Act that I think is interesting is the specific context that it was built in. So this isn't exactly your question, but I have heard this raised multiple times, that people are asking whether the AI Act should just be wholesale adopted in the US, whether this is something we should do, whether we should look at a different model. You floated some additional models that we could look at, like the FDA, like early approval of a technology before it goes out on market, so you can identify risks. I think that's an interesting approach. The reason that I don't think the US can wholesale adopt the AI Act is the EU has an entire infrastructure and network of other policies that establish privacy rights and that establish data requirements and that establish like all of these other restrictions that are already in place to give people rights. The US unfortunately doesn't have that. So if we were to basically copy paste the AI Act in here, it would be coming in as a freestanding law that doesn't interact with all of these other laws that are in place in the EU. And I think it would be incomplete and would have even more gaps than whatever we'll see pop up in the EU. I think it'll be interesting seeing how this is applied. I think the risk-based approach is an interesting one. I also do have some concerns about the areas where companies are allowed to self-evaluate what category of risk they fall into, because there are very different requirements depending on what category you fall into. And some of the way that the Act proposes companies assess their level, they can be very open to interpretation or argument. So if a company really doesn't want to do all of the requirements of the high risk category, and there's any way they can argue they don't fall into that category, even when they pretty obviously should, they're going to try and argue that they don't fall in that category and hope that they either don't get noticed as not fulfilling all of the requirements they would need to fulfill if they were in the high risk category, or that if they get called on it, they have kind of a plausible deniability of, oh, well, we just didn't understand. We must have done it incorrectly. It was too broad. There wasn't enough guidance type thing. So I'm a little worried about that as an issue as well. One other thing that I want to raise that I'm a little concerned about is in the prohibited category, there is in general a full ban. There is one area where there is a loophole if it is used in a specific context, and that is for live public facial recognition by enforcement bodies. That is allowed in certain circumstances and otherwise prohibited. The worry I have with the loophole here is the same worry that I generally have when it comes to people talking about like building in backdoors and encryption, is that if you build in a way to use that thing, suddenly the door's going to swing wide open and you're going to have so much less control than you think over how that gets used. So I'm nervous that loophole will be exploited. And in general, I think it's a good approach that they went into this as a risk-based option, because it does force people to focus on potential harms and think about how things can go wrong. And I think that is a good approach. The interesting and challenging thing is seeing how that's applied and how that ends up working in practice, like whether the way they envisioned this law rolling out and the way they envisioned it protecting people actually ends up protecting people.
So one thing, there's sort of the level of first, identify the risks. What are these risks, and how is it being used, and what are the purposes, and then classify the risks, and basically, we have this kind of red line, can't do it, prohibition, except the one loophole you mentioned, for certain uses. And these are, for, like really bad uses or problematic uses. And then you've got, the high risk category where you have all sorts of requirements. And then, for other things that don't fall into either the other categories, you have the transparency requirements, but generally the law doesn't say much else about them. But when you go to the high risk, look at, okay, what happens if you have high risk AI? What do you have to do? And there's sort of design requirements and then governance requirements, the typical mix of, be transparent and, have, instructions and have human oversight, things like that, documentation. But, and I wonder in privacy, a lot of these have been critiqued as being, things that, companies can kind of just do in a fairly, cursory or, it's very, very easy just to produce documents and produce things and make processes and make things kind of look pretty. Professor Ari Waldman, critiqued a lot of these things in privacy law, saying, it's all just an elaborate, facade. But it doesn't really move the needle. It doesn't really do much. Companies can easily document anything and justify anything and put out everything. And so I wonder, are the things that you must do for the high risk sufficient? Or should there be more restrictions? And it's just still putting a lot of, not only do the companies kind of get the first crack at the risk determination, but then they also are largely relied upon to, produce things if it is risky. So I wonder, is that enough, or is there something else that the act needs, or will this really provide the adequate protection if we do have high risk AI? Do either of you want to jump in on that or have a thought on that?
Sure, I'm happy to. I'm sure Calli has thoughts too, but I'm happy to kick it off. I think a couple points to make there. I think conceptually, does this advance the ball? Does this move us closer? Does this give us some kind of meaningful oversight? I think the answer is yes. It is definitely not perfect. I don't think it's complete. We don't have all the information yet. We don't have all the guidance yet that's going to eventually be included. But it doesn't have to be all of that at the moment of passage in order to be useful, I don't think. I mean, we have already seen impact on companies' operational planning for AI-based systems just because of the notice that this was coming and the sorts of things that were going to be involved. So it is going to impact things. And I do think it moves the needle. And it's one of those sort of like, not letting the perfect be the enemy of the good, or even the mediocre, whatever your opinion of how far that needle is moving might be. Because my answer is always to the people who make those sort of critiques is, well, if we keep not doing anything in the search of the perfect or super, super really high level great thing, it's just that much more time without any of the protection. So I'd rather see some reasonable, legitimate controls, even if they're imperfect and insufficient for all cases, go into effect, and then we can start to build on them. The regulators will, start to see what are some of the consensus decisions around this. What do they think about that? Where do they want to, they can set a threshold and then they can change it later if that ends up not being sufficiently protective based on standards, which, yes, some harms can happen in that process. But again, it's kind of like those harms are going to be happening one way or another. And we can't preemptively think of all of them and put into place something comprehensively enough that will actually address everything in advance. I do think that there are some real valuable oversight tools in the AI Act as it exists today anyway. So I don't think it's even just sort of a notional improvement. I think technological testing, AI as opposed to privacy, for all that, they both have a lot to do with data. And so we, continue to talk about them together, are really very different things. So AI, by its definition, is a technology. It is a system, a model. It is a process that is, based in something physical in your computer and, maybe cloud-based and whatever, but it has a function. And so we can test that. And there are not perfect tests yet, but the Act calls for audits. Other tests, other laws in the U.S. Below the federal level or at the agency level have addressed audits. It's something that my firm has been doing for several years now for predictive AI systems, not just generative AI systems, is how to apply known and proven statistical measures to assess the performance of a model against like a bias standard to determine whether it's in reasonable compliance with civil rights laws. And these are things that we can do. We can design processes to do that statistical testing. Then we can decide what metric it needs to be measured against. We can decide, is that sufficient? Obviously, there are different ways to apply some of these statistical tests. We can look at legal precedent to say, here's how we assess whether this meets an established civil rights interpretation for a 4/5 rule or a disparate impact standard or things like that in the US at least, and EU has the equivalent for how those things have been interpreted. So there's sort of a whole infrastructure of things that we can actually start to measure and evaluate against with levels of objectivity clearly available and in place. And and then continue to iterate those, continue to improve them, continue to assess them and decide, are they sufficient? Do we need different tests? Do we need more comprehensive tests? Do we need tests, differently for generative AI, which, the answer is pretty much yes, but we're already starting to develop structural approaches to that as well. So I think there's very real substance there, and it is very definitely impacting the developers and the sellers of these systems and the users of these systems, honestly, I think, as well, as they become more aware of some of the controls, just like people got a little bit more educated about privacy and understanding what some of the questions to ask were. They'll start to understand in this new context as well. And then we can keep moving forward with that. We can, update guidance, issue new regulations, change technological metrics and measures and standards against which they're measured. NIST in the US and other organizations around the world are definitely already working to figure out what the best ways to measure some of these are. And it won't be AI. It will be, facial recognition systems or voice-based technologies or predictive systems for, credit scoring or workplace performance monitoring systems or something like that. Each one of those is going to have, some kind of standard or metric around it. So sorry, that was probably too long, but let me pause. I think the short answer is yes. It moves the ball forward and gives us a good platform on which to grow.
Calli, do you have any thoughts on this issue, on the measures? Is anything missing? Does it give a little too much to defer to corporate oversight, or does it or is there something else that could be added, or is that going to be enough, or is it hard to do anything else?
It's hard to say whether it's going to be enough. There's a couple things that I think could be added, and there's some things I think could be modified to make it stronger. And I do agree with Brenda that we have a tendency, particularly in civil society, because we see our role as being the groups that push for improvements and that find the holes and that find the risks and the gaps and point those out so that we can get laws passed that are stronger and that are better than, like, always striving for better. But pointing out that there's flaws doesn't mean that the base is all bad. We're not trying to necessarily throw out everything that's not perfect, even though that absolutely is something that comes up in the space. And don't let the perfect be the enemy of the good is a good reminder for us to keep in general. For this, I think it's really interesting that a lot of the requirements they have in the high risk category echo some of the best practices you see when it comes to like privacy principles. So transparency, accountability, record keeping, tracking these systems. These have never been perfect measures. They, like, if you can follow these measures and still have something that's violating privacy, or in this case, violating the spirit of the AI Act, violating consumer rights, has risks. These are never going to be perfect fail safes when it comes to protecting people and protecting society from AI damages. But they're a really good first step. And the function that I saw with them when I was working with them with companies is that they force people to think through the process in a way that they may not on their own. In general, priorities when you're building a product are, is this going to function really well? Is this going to be popular? Will this sell? Will this make us money? Will this be good for the company? You're not always necessarily thinking about what is going to be the broader societal impact, and are we tracking what information is coming in and how it's evolving, and are we documenting how we're building out all these different iterations of a system so that if something goes wrong, we can go back and see what's happened there. Are we going to have documents on hand if there is an authority that is, like, if something goes wrong and the authority has questions about what we consider and what our process was and how we built this out, will we have something we can show them that shows we made good faith effort to think these things through? I think all of those are good practices. And at the very least, they're the building blocks that you can use if it comes down to having to say, hey, clearly this is not enough. There are gaps here. There's still a huge volume of risks happening. This at least documents things and forces companies to ask those starter questions in a way that you can build from if you need to add strengthening measures. So some of the strengthening measures that I would like here are, I can't remember for sure if there's mandate. So in general, when there's assessments, when there's documentation, that sort of thing, I think the strongest measure is to proactively have to turn in and file that documentation so that authorities have easy access to it. And it's not just when something goes wrong, they can request it. There are definitely ways you can do that that are more secure, that don't necessarily violate confidentiality and that don't risk business secrets or trade secrets. But I think having that documentation already turned over on hand adds a level of transparency and a level of accountability there that is really, really helpful. So that is something that I would look for. In general, I think it's really interesting that the way that they set up tracking liability here, it's a real challenge when you're looking at things like open source models. They tried to address that because, sorry, not to get too technical in the weeds of the wording here, but for several of these assessments, what you're looking at is the intent for the use of a system. And that's kind of what determines what category it falls into. Open source systems are challenging because they're a framework and they're intended to be open for people to modify and use as they want. So the intention of each individual modification of that system is going to be different. There may be hundreds of systems that all come from the same open source model and have been modified in different ways. And some of them may genuinely be high risk and some of them may genuinely be low risk. And it's going to depend how that's implemented. But then there's the question of, does the liability here fall on the person generating the open source? Does that fall on the person doing the modification? How do you track that? How is that going to be argued? They've made it fairly clear, I think, in the regulation that the intent there is when there's a modification, the liability falls on the person that did the modifying, and the liability tracks from the point of the modification onward and then to future uses. But it is squishy enough that I think that's going to take a lot of resources from enforcement bodies if they have to do enforcement actions in that space. And that's just an area that's a little squishy that I'd like us to reconsider. I think this is a good first step, and I think this is a building block. I do not think the steps that are required in the high risk category are going to be sufficient to fully address all of the categories. My guess is that there's going to, as this goes into play, as companies have to start complying with it, as we see how this plays out in practice, we're going to be able to identify where the gaps are a little better. But this may be something that we can't fully see what all the issues are or address them until it starts going into practice.
Yeah, I think you both raised issues that I've really been struggling with. I'm torn on this. I feel that I know fairly well have a vision for how privacy should be regulated, and even how privacy and AI should be regulated. But AI generally is a challenge. I think that there's this tension between how proactive or reactive we want to be. I don't think it's great if every time someone's developing an algorithm, they have to go and check it out with an agency or get some kind of pre-approval for that. I think that would be not an ideal solution. It gets the government involved way a little bit too much. On the other hand, is the reactionary. Should we just wait till something like really bad happens? It could be really bad, and oftentimes when something bad happens, what I've seen in the law, and a lot of times in privacy especially, is that the penalties are never, like, that's never enough. I mean, generally, companies will just take the risk, and it's better to ask for forgiveness than for permission. And so there's a tension here, and I don't fully know how to resolve it, but I struggle with it. And I think this raises, this brings us to another issue, and you mentioned this briefly, Calli, with general purpose AI and generative AI. And those are different things, but they have overlap. General purpose AI is that AI that's usable for a wide array of purposes. And what we see is that a lot of AI models are being thrown out into the world. Hey, here's this, and it's open source, it's out there, and then various companies and individuals can use it for however they want, for any kind of purpose. And it's one thing if we have a specifically defined purpose, and then we can say, okay, that we don't like that purpose, we don't like facial recognition, we can try to restrict that purpose. But a lot of AI is just thrown out to the world for any purpose, and anyone can do anything with it. And to some extent that's very open and democratic, that hey, AI for everybody, and I can use the model to do different things with it and adapt it. And we're seeing also that the AIs, a lot of players are in this, playing around with it. They're the creators of it, but then there are people who modify it, who take it and then make changes to it, integrate it into things, or use it in different ways, and those ways could be nearly infinite. And I think the Act really struggles with how do you regulate that, when the uses are so varied. And I think we see that with generative AI. Generative AI is AI that generates content, like it can create images, it can create text, it can create video, it can create things. And generative AI isn't the kind of general purpose AI. It's used to do all sorts of things. I can have it write stuff for me, all sorts of things, and do all sorts of things with it. And it's up to the user to decide what they want to use it for. And companies say, don't use it for bad. But there's it's still up to, and it's still putting a very powerful tool in the hands of people, in the hands of others, to use it in all sorts of ways. And some are going to use it responsibly, but some are not. And I guess might come to a question now, well, does the Act address that well enough? I mean, it's great if it's easy if you have AI that's only limited to a specific purpose, and then we can say, okay, I can assess the risk of that purpose. But I don't know how to assess the risk of, let's say, a chat GPT, which is kind of a general purpose generative AI tool. What's the risk? Well, there's a gazillion risks. It kind of depends on what the gazillion people using it are doing with it. And so I wonder, like, what does the Act handle that well? And then what do we do with something like that? And I guess I'm torn too, because I like the idea that, hey, AI for all. I don't like, okay, only like, the very big companies, like only Mark Zuckerberg and Elon Musk can have AI and do stuff with AI. I like the fact that, hey, I can do stuff with AI, or I can get a model and I can, adapt it and do stuff with it, use it if I want to use it. But then the danger is, well, anyone can do anything with it. And, it's great if I can do everything with it, but I just don't want anyone else to do anything with it. Trust anyone else. But then how do you regulate that? Because it puts a lot on the user, and the user, could be anyone. And it's almost, so I just wonder what's the answer? Does the Act have the answer?
Personal opinion, I don't think it does. I think this is one of the areas where the Act is weak. And I'm not blaming the lawmakers for that. I know that general purpose AI and generative AI were both kind of last minute additions to the discussion of the AI Act. And so they kind of tried to shove it in where they could and address it kind of, but it's not really in there. And I don't think either of those areas had the kind of robust discussion, and discussion with technologists and with companies that are developing this and with people that evaluate risk. I don't think it had the kind of discussion that would allow for it to be fully addressed within this regulation. So that, I think, is a pretty significant gap that would need to be improved on with amendments or maybe additional regulations in this space. I do think it's a huge challenge to address these things. This is extremely complex technology, and particularly when technology is democratized and there is open access to people, which I agree with you. I don't think it should be siloed, and I think it would be unfair if we had like a tech class system here, but there's risks that come with that, because you can't control what everyone does with that. That's something that we're looking at, in particular right now when it comes to election misinformation and disinformation from AI. You can't control if someone decides to make a bunch of images of candidates doing weird things and spread them all over the place. There are some questions there that I think would be interesting to talk about addressing, but I'm going to caveat this little segue by saying very openly, I am not a technologist. I talk a lot with technologists. I ask a lot of very basic entry-level questions so I don't embarrass myself. But I am a lawyer and I am not an expert on this side of things. And I try to be really honest about that. With that caveat out of the way, I do think this is an area where it may be useful to have pretty open discussion with technologists about what's possible when it comes to technological limitations on AI systems. Like, is there a way to build in certain kinds of filters or protections where an AI, if it receives certain kinds of prompts, just will not produce an output that reflects those prompts? That way, for the most dangerous uses that we can predict, maybe we could build some barriers in there where, like, that's just not an option with this AI system. I don't think that particularly would hamstring the useful aspects of AI. I think that would still allow for some really interesting uses. But if I speak with technologists and they can confirm that that's a possibility, some technological aspects may be another approach. I think in this case, it may be necessary for us to have a multi-pronged approach to addressing risk. So regulation is great, but you probably need more than that to fully deal with the problems we're seeing here.
Yeah, a quick thought that came to mind when you were talking is, well, can we just, build in, limits? In a sense, it's like giving people a car, or selling people a car. Hey, everyone can now have a car and it can do all sorts of good things, but it also can, run over people and do terrible things if people don't drive well. The problem is people don't drive well. And we can limit certain things that people can do in the car, but do we just say, hey, we'll just make the car and they can't go above the speed limit, and then we just won't have them able to do that, or and we don't generally want that, right? We just kind of give it to them and kind of, but we do have a lot of restriction on use and everything else. But it's a lot harder with technology, right? It's a lot harder to say, hey, I'm going to give someone this model, and then someone can modify it a lot more easily or readily than perhaps they could do a car. Maybe I could rig a car to do certain things that it's not done. You can try to jailbreak things, but technology can in some cases could be easier to kind of break free of restrictions that people can do. So you're kind of giving people a car with AI that's very, very powerful, but that ultimately, it's going to be a lot harder to put those hard limits in, or maybe we can. But that's I guess that's sort of, we could also say maybe that's just the problem with the internet, right? We gave people the internet, and everyone uses the internet, and I think it's been good for society, and it's also been terrible for society. It's kind of been everything, but we've given this, and I guess this is just going to be an extension of that, perhaps. But Brenda, do you have thoughts on all this? General purpose AI, giving it to the AI for the people. Is there a way to meaningfully regulate this? And I think I agree with Calli. I think the AI Act kind of struggles with this, doesn't quite know what to do, because it throws a big wrench into the approach of, okay, you have risks, but that depends on a specific purpose of use for AI. But then when you have AI that can be any use and anyone can do anything, it makes it a lot harder then to wrap that model around it.
Yeah, I agree that the EU AI Act is a little awkward on this point, because, as Calli pointed out, the process brought this in very late in the game through no fault of their own. It just didn't exist when they started. And then so they've tried, through various needs to reach consensus with their members and things like that to find a workable solution. So, kudos to them for getting it included and getting it across the finish line with that in there. But I do think it's not, at the same level of sophistication and approach that the rest of the act maybe is. I think, to maybe overstate the obvious, it's gonna need a balance between what can you require of the general purpose system at its general purpose scope and layer. So, for example, the early LLMs of various brands when they were first introduced and people first started playing with everything and realized, oh, this thing called hallucinations, it can just make things up. It could make up really specific detailed things like a whole federal agency or an academic research paper. I think you, Dan, posted a biography of yourself that, it gave you a degree from Berkeley or somewhere that you didn't actually have. So as soon as that became obvious, all of the models were then updated to say, with this little warning label at the bottom, that information should be validated. Information may not be accurate, should be validated. And they're going to continue to try to make it better. They're tying it in together with search engines, trying to tie it to things that are more trained and grounded in accuracy, which LLMs are not about accuracy. So trying to marry up those things. So I think there are things that can be identified and assessed and included in requirements for that. We know already that all of the LLM producing companies, big or small, are automatically going to be building in various rules-based filters and controls on those systems to address the most commonly agreed upon threats, things like child porn and excessive violence and things like that. And a lot of that is pretty well done in the sense that you have to pretty intentionally and directly and an entire violation of the terms of service that you've agreed to work hard to get it to do some of that really very easily. I'm not at all going to say that you can't, and I don't want anybody sending me examples of things that they managed to convince it to do, but there's definitely the evidence of the fact that there are filters in place that limit just the basic interaction of systems to do some of the things that everybody agrees really shouldn't be done. So there are things that could be done there. It is a general purpose system. It can be incorporated into other things. It could be used for other functions, in which case it would fall into the high risk category for those functions. So if it's incorporated into, a biometric system, or it's incorporated into an employment application system, or it's incorporated into something else, now it's already being used in a context that is either already designated high risk, and that system that it is incorporated into will need to meet those high risk requirements. Or maybe we need to look at, additional things that might need to be required when open source systems are included in these, or when different aspects of this. So I'm not saying it actually does all that effectively yet, but I think that there is already a little bit of an idea of how that could be approached between the things that would apply to them generally and at the source versus the things that would apply at the implementation level when they're incorporated into other systems. And, working with companies, I have seen sort of things all across that spectrum down into the very detailed, hyper-focused, RAG or fine-tuned, informed, targeted uses of these systems, back to all the way at the just public access to the general LLM and the ability to sort of do whatever you can do in whatever way you can do it. And so there's going to have to be some sort of way of considering from a legal standpoint where the liability falls when things go wrong all along that spectrum, but also from a regulatory standpoint, how do you measure and assign responsibility for maintenance and upkeep and transparency to the different levels of that. So I think that's kind of what's there now, but plenty of room for improvement.
Yeah, it is really challenging because I'm seeing so many deep fakes now, so much use of AI to, create fake videos and fake images, despite, attempts to try to limit this stuff. The fact is that it's really hard to put these limits on, and to what extent can the law do that, especially if a model's put out there, and then, someone could kind of modify it to take off any of these limitations. I don't know how you kind of fully bake it in, but I think having it in there is good because there's a lot of people who might lack the sophistication to do that. But then there's always going to be, the bad people come along who will, publish one that isn't that lacks those protections, and then we run into issues of can they be regulated? Can they be stopped? Can you, is there First Amendment implications for creating and publishing an AI model that lacks protections or that could be used for bad purposes? It's a really difficult problem. I think that maybe the easiest thing is just get rid of bad people. That would be the answer for law. If we weren't bad people, then we could regulate things so well.
Can we get rid of all the bad drivers at the same time if we're taking this approach to law or to compliance?
Yeah, I would love it. At least where I live, that's pretty much like 90% of drivers off the road, which I love.
But we're all somebody else's bad drivers. I think my point. If I could just make one comment about the deep fake thing, because I think that's a really interesting example. Because it really shows both the complexity of this and the limitations of trying to address it from an AI point of view. You don't have to have AI to do a deep fake. So we have plenty of examples of, photoshopping and video editing that already existed completely, wholesale 5-6 years ago, before generative AI, even before any other kind of AI, and they're very convincing videos of, Nancy Pelosi slurring her words, or Barack Obama speaking over, with Taylor Jordan's content, or whatever it is. Jordan, sorry, I'm getting names wrong, but that's the problem of talking live. But the point is, we also may not want to just say, do away with deep fakes, because that's not necessarily going to actually solve the problem we're trying to solve, which is misinformation or disinformation, at least in the way we're talking about it right now. Because I could still generate an AI version that's not a deep fake, in the sense it's not a real person. It's just an AI generated avatar image of a person. So I'm not deep faking somebody and making Dan Solove say that privacy no longer matters. I'm just creating a person who says privacy no longer matters, and I can still wreak election harm, and I can still spread that information, and it may not carry the same total impact as if I can make it look like it's coming from Dan Solove, but I can still have that impact, which is the harm that we're actually worried about. And interestingly enough, the EU AI Act makes deep fakes one of the limited risk things. And I think it's because they also have in there this requirement for anything that's AI generated to be labeled. And they're hopeful, I think perhaps overly optimistically so, that there's going to be a way to consistently and effectively do that. So if something pops up with some kind of label or watermark or flashing red light or whatever that says this is a generated thing, now go ahead and listen to it, that people will somehow take it less seriously and be aware of the fact that it isn't really Dan Solove, disrespecting privacy, but it's a fake. I don't know that that's really a sufficient enough protection. I don't know that that protection is realistically enough available at this point, feasibly, technologically, to label these things. But I just think the deepfake example is a really interesting one because of it doesn't have to be about AI. It does beg the question of what are we actually trying to protect as the underlying problem, which is really more about disinformation. And can we actually encode technological solutions that limit the risk of it, even if the information itself is still going to find ways to get out there?
But it does put it on steroids. I mean, I've used Speechify to put my voice into, narrate changes in programs, and it does a good job. I mean, it sounds like me. And
one thing to build on that, just really quickly, is that I think we're seeing with AI something that we see really commonly, like that I also saw with XR technology when I was looking at that, is that in many of these cases, the actual risks and harms we're seeing, it's not that they're new, it's that the volume, speed, and convincingness of these things is just heightened so much. So the speed at which we're able to address it is challenged in these things. But I do think that also provides some opportunity, like, speaking from a very privacy specific angle, we're seeing a lot of enhanced privacy risks in AI that have always existed and that we've always said were problems. They're just now problems at a scale and a speed that are frightening. But the bright side of that is that it gives us even extra fodder for the arguments we've continued to make, which is that a lot of these things could be addressed if you had a good privacy law in place. Like, if we had a federal privacy law, I'm not saying it would solve everything, but it would certainly help with a lot of these things.
Well, I think that's a good note to end. It's definitely something I strongly agree with. And I think that, with privacy problems, I wrote a piece and my argument was that, AI does, have this amplification and this speeding up effect and kind of puts a lot of these problems that have existed for a very long time on steroids. And a lot of them are things that privacy law still needs to deal with. It's trying to address the problem. It just addresses them in I think the wrong way, and in ways that are not well suited to the technologies that are being used, especially AI, which is just something I think is just too complex for a consumer to think that you could just use consumer rights to address it. I think that we need a lot of laws in a lot of areas to address AI. I mean, we have the AI Act, but in a sense, the AI it's kind of like regulating the internet. The AI is kind of AI is in kind of everything these days, and despite the fact that everyone wants to call everything AI because it's so sexy to call everything. So anything that has a kind of any code in it now is AI, but AI is kind of going to be in everywhere, and it's going to be hard to escape. It's going to be like the internet, and so we're going to have to regulate in all these different areas. We'll have to touch on AI, privacy included, and I think that the act is not a privacy law. It's a general broad law on AI, but we're going to need a lot of the specific laws addressing specific things to tackle these problems. Want to thank you both for a really fascinating conversation. This is a law that in an area that I'm going to follow for a while. And I just want to thank the audience for listening to us. And again, if you want, I did create this little short summary of the act, trying to summarize a very, very long act into just one page. So there's a lot missing, but at least it'll give you a kind of quick overview of what the act covers and how it basically functions. I look forward to continuing to talk to both of you further on these issues. I think this is very early stages of how the law is going to try to wrap its arms around AI. And I think, we have a lot to wait and see and a lot of things to come. We didn't have a chance to discuss other laws that are created about AI and are in the pipeline for being enacted for AI. You have the Colorado AI Act. You have a lot of bills, so we're going to see a lot of activity, and I think that could be a great conversation for another day. Is what else is out there, and how else might we try to tackle the problem? Are there other policy approaches? So thank you both, and I really enjoyed our conversation. Thank you all.
Thanks, Dan.
Thank you so much.